Welcome to the Power of Offense with Keith and Rodney, and I'm your host, Keith, and right below me on your screen is Rodney.
Greetings.
Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. Now, today's show, we're discussing fair use in relation to copyrights. Now, as you can see on your screen, we have a comment from one of our listeners that left a comment in the comment section of one of our videos. And this individual's name is Bachata Intimate. And Bachata Intimate said, "Did you get permission for Kevin Samuels to show his clip? From lawyer to business owner, fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use." Now, before we unpack this question, we would first like to thank Bachata Intimate and say that we appreciate your comment. Now, we appreciate it because our assumption is that you want to keep honest people honest, meaning you want to make sure that we are following the law. And we appreciate that. And we actually agree with your sentiment. Now, let's read it again. Bachata Intimate said, "Did you get permission from Kevin Samuels to show his clip?" Now, we're going to answer that later in the show, okay? And then he says, "From lawyer to business owner." So we're assuming that Bachata Intimate is a lawyer. That's the assumption, y'all. All right. Now, what is a lawyer? We have a definition for you because we want to set the stage to everything that we're saying in this broadcast. Now, a lawyer is a person who practices or studies law, an attorney or a counselor. All right. So just from the context clue within the sentence, it's implied that Bachata could possibly be an attorney. All right. A lawyer, a lot of times lawyer attorneys, people use them interchangeably. All right. Now let's go back to the comment. He said that fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use. Well, we're going to unpack this, y'all, in the show. We're going to take a look at fair use. And we want to try to discover why is Bachata Intimate saying this, because we can assure you that the videos that we put out, the videos that we publish for you all, right, that our videos are protected under the fair use doctrine. All right. Now, let's look up a definition for fair use. So right here in Google, we have a definition for fair use. And matter of fact, let me zoom in a little bit. Make this a little larger. All right, definition for fair use. It says in U.S. copyright law, the doctrine that brief excerpts of copyright material may, under certain circumstances, be quoted verbatim for purposes such as criticism, news reporting, teaching, and research without the need for permission from or payment to the copyright holder. All right. Again, it says in U.S. copyright law, fair use is the doctrine that brief excerpts of copyright material may. So in this case, we're talking about a video that we published where we were discussing the lawsuit that Jessica, aka Miss Average at Best, filed against the popular YouTuber and image consultant Kevin Samuels, right? So that's the material that he's referring to that may have been copywritten, right? Now it says under certain circumstances can be quoted verbatim, meaning that we played his video verbatim, right? For purposes such as criticism, news reporting, teaching, and research. Now I can assure you that this definition is missing comment, the word comment, okay? And then it says without the need for permission from or payment to the copyright holder. All right. So let's take a look at something, y'all. We have a slogan, and we say this slogan at the beginning of all of our shows. And we also have a notice that's within every single video that we publish. Now, this slogan, right, is a statement. And this statement is that here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. All right. Now, again, I can assure you that fair use right? That it protects commentary, right? And we're going to check that out in a moment. So here at the Power of Offense, right, we entertain you with legal commentary from a layman's. Now, let me define layman for you. Here we go, layman. Now, we're looking at the second, right here, the second definition. And it says a layman is a person without professional or specialized knowledge in a particular subject, all right? That's what we are. So we are individuals, right, without professional or specialized knowledge in law. That's what we're saying, okay? Now let's go back to our slogan. Here we go. So again, here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. So we're giving everyone our point of view, right? By applying law to whatever situation that we're discussing. That's what we do here. All right. So we're setting the stage to explain to Bachata Intimate, right, how we know that we did not, or how we know that we are protected under the fair use doctrine. Okay. Now, let's move on. Now, the reason why this is important, right, is because we understand that ignorance of the law is no excuse. All right. Ignorance of the law is no excuse. Not for me and not for you. Now, right here on your screen, right, we have ignorance of the law is no excuse. And we're going to take a look at this Wikipedia publication. All right. Let's take a look at this. All right. Now, this is basically saying ignorance of the law is no excuse. Now, this is Latin at the top, right? This is Latin, y'all. I'm not sure how to pronounce that. Okay. So we're going to skip.
Non-excuse.
Thank you, Rodney. Which basically means ignorance of the law excuses not, right? And then we have a footnote. It says number 1. That comes from Black's Law Dictionary, 5th edition, page 672.
It's also a maxim.
Say that again, Rodney.
It's also a maxim of law.
Right. Yes, it is. And then it says ignorance of the law excuses no one. Footnote 2.
Yeah.
Yep. Yeah, from Black's Law. Yep, 5th edition. Page 673. That's for those who have a 5th edition Black's Law Dictionary that want to check that out. All right. Now, it goes on and it says that both of these, right, respectively, are legal principles holding that a person who is unaware of a law may not escape liability for violating the law merely by being unaware of its content. It says in European law countries with a tradition of Roman law may also use an expression from Aristotle translated into Latin. You want to read that for us, Rodney?
Nemo Center Ignora legem.
Which is nobody is thought to be ignorant of the law. Or
ignorantia loris nocit.
Not knowing the law is harmful. Y'all hear that? Now that's important.
That's probably the best one right there.
Yeah.
The law is harmful.
It's extremely harmful. You know? Now, like Rodney said, these are legal maxims. Now, what is a legal maxim? All right. I have a definition for that. See, we got to set the stage for this for everyone. Because we're going somewhere with this. Let me zoom this in. All right, here we go. Maxim. It says a broad statement of principle, the truth and reasonableness of which are self-evident. A rule of equity, the system of justice that complements the common law. It says maxims were originally quoted in Latin, as you can see, and Rodney read those for us beautifully. And many of the Latin phrases continue to be familiar to lawyers in the early 2000s. So the fact that maxims, right, are familiar to lawyers, that means that Bachata Intimate should be very familiar with ignorance of the law is no excuse, right? And we're assuming this. And we're assuming it's based upon this definition. Now it says the maxims were not written down in an organized code or enacted by legislatures, but they have been handed down through generations of judges. As a result, the wording of a maxim may vary from case to case. For example, it is a general rule that equity does not aid a party at fault. This maxim has been variously expressed, and we're just going to read the first one where it says, no one is entitled to aid of a court of equity when that aid has become necessary through his or her own fault. Now, to me, right, when I hear that maxim, that equity does not aid a party at fault, that also translates to me that ignorance of the law is no excuse, right? Because if you're not ignorant to the law, then chances are, right, you will make great decisions and you won't be liable within whatever the situation is. Do you kind of get what I'm saying, Rodney?
Yeah.
Trying to make sure I explain that right.
Yeah. And that, yeah, pretty much. But you pretty much summed it up. Like, ignorance of the law is no excuse. So this maxim is pretty much saying that don't try to sue someone. And it goes back to one of the other videos when we talked about contributory negligence.
Yes.
But here you're like contributing. You can't contribute to someone else's negligence where you suffered an injury and you're at fault. Equity will not relieve you. That's what it's saying. So it really covers both.
I agree. I definitely agree. Now, I want to go back to this Wikipedia. I'm calling it a publication, but I don't think that's the proper word to call it. Should I say this Wikipedia definition? Maybe I should say that.
Yeah.
You know, and again, you know, let me also say this, that we know that Wikipedia is not an official source, meaning it's not an accredited source that you can use in an educational institution. We know this. However, Wikipedia does have awesome write-ups and it does explain information very well. Plus, the individuals who input information, in most cases, they also leave footnotes so that you can see, right? You can see where they citing their work from.
References at the bottom.
Yeah,
so that's why I like Wikipedia, because although you can't use Wikipedia, you can get Wikipedia is more of an overview. You can go down to the references and really quote if you're doing any type of briefs or any type of college research. You can read it on Wikipedia, go to the research, go to the references at the bottom, and then quote the references. So this is, to me, is like a great overview of what you're trying to accomplish, but make sure you go to the references, one, to verify, and two, to make this make what you're reading in Wikipedia, what's the word I'm looking for, admissible. You know, right. It could be admissible in college, it could be admissible because my wife teaches college and she says that no one can use Wikipedia. But then when I explained to her that they can go down and do the references, she said that works because they're not using Wikipedia then. You see what I'm saying? So they're using the references from Wikipedia. Wikipedia kind of like gathers, it does homework for you. You just have to make sure you verify it and use the references that they provide.
Exactly. Yep. Now, I wanted to read just this first paragraph on the explanation. And it says the rationale of the doctrine, right? And again, we're talking about the doctrine of ignorance of the law is no excuse. Is that if ignorance were an excuse, a person charged with criminal offenses or subject of a civil lawsuit, right, would merely claim that one was unaware of the law in question to avoid liability, even if that person really does know what the law in question is. Thus, the law imputes knowledge of all laws to all persons within the jurisdiction, no matter how transiently. Even though it would be impossible even for someone with substantial legal training to be aware of every law in operation in every aspect of a state's activities, this is the price paid to ensure that willful blindness cannot become the basis of exculpation. All right. Then it says, thus, it is well settled that persons engaged in any undertaking outside what is common for a normal person will make themselves aware of the laws necessary to engage in that undertaking. If they do not, they cannot complain if they incur liability. Now, I agree with that. To me, that makes sense. And again, that's what keep honest people honest. I agree with it. And I'm assuming that's what Bachata Intimate was attempting to do with us. That's my assumption now. Now, I want to take this even further, right? And I want us to take a look at a Supreme Court decision, right? Where the Supreme Court explains that ignorance of the law is no excuse. Now, it's a reason why we keep on going over this. It's a reason, and we're going to get to that in a moment, all right? But I also want to read that to you right now. All right, y'all, here go the case. The case is Barlow versus United States, and this case is from the Federal Supreme Court, 1833, all right? Now, the Federal Supreme Court is an authoritative source, meaning it is a primary source. All right, y'all. Now, before I even read this, matter of fact, let me prove it to you all by definition. And this definition is coming out of U.S. Legal. You know, I think we need to read this again, Rodney, because, you know, we understand that repetition is the, the cousin of learning?
Yes.
I believe I'm saying it right.
Yeah, close enough.
Yeah. Here we go, y'all. It says authoritative sources. It says an authoritative source in the legal context is a body of law which takes precedence over others. An authoritative source is known to be reliable because its authority or authenticity is widely recognized. All legal information comes from either primary or secondary sources. Primary sources articulate the law. Primary sources include the following: constitutions, treaties, and other binding international agreements, statutes as enacted, statutes as codified, agency regulations, court decisions, right? We're dealing with court decisions. Decisions by agency adjudicative bodies, executive orders, presidential proclamations, and certain government orders, such as some military orders, including some verbal ones. Now, it goes on and it says court decisions, often referred to as case law, have their own hierarchy of most authoritative to least authoritative. Within the federal system, case law from the United States Supreme Court is the most authoritative source of law on the issue. Next will be case law from the Federal Circuit Court of Appeals, then decisions by federal district courts, and then it says in the state context, the decision of the Supreme Court of a particular state is the most authoritative source of law on a state law issue, followed by state appellate courts and state district circuit courts. Now, please keep in mind that our United States Supreme Court is authoritative over the entire court system in America. The court systems in America all adhere to case law from the federal United States Supreme Court. Am I right, Rodney?
Yeah. So that's even the Supreme Court over a particular state. So a particular state can rule one way and use its case law. You can go and find a Supreme Court case in the Supreme Court, United States Supreme Court, and it'll overrule that case.
Indeed. So here we go, y'all. Barlow versus United States. And this is from 1833. All right. So we're going to read something here. We're not reading the entire case, right? But we are going to read just a small portion of this. All right. Here we go. And I'm going to highlight this for everyone. All right. There it goes. Now, it says it is a common maxim, right? We're talking about legal maxims, y'all.
We just discussed maxims.
Yep. Familiar to all minds that ignorance of the law would not excuse any person. Now, any person means you, me, Rodney, Bachata Intimate, or anyone else. It doesn't say it excludes you if you're just a basic layman or a private citizen. It don't say that, right? So the same way that an attorney or a lawyer is held to the standard of knowing the law, you are too, as a private citizen. It says any person, either civilly or criminally. And it results from the extreme difficulty of ascertaining what is bona fide, the interpretation of the party, and the extreme danger of allowing such excuses to be set up for illegal acts to the detriment of the public. There is scarcely any law which does not admit of some ingenious doubt and there would be perpetual temptations to violations of the law if men were not put upon extreme vigilance to avoid them. Now, this judge, right, that wrote this opinion is saying exactly what you heard in Wikipedia. The judge is just saying it, in my opinion, in a more complicated manner. What you think, Rodney?
Yeah.
This is judge talk, legalese.
Legalese, that's what I was about to say. Legalese at its best.
But the judge is making it clear that ignorance of the law is no excuse, and everyone, right, all persons must be held to this standard, because this will what's the word I'm looking for? This will diminish the perpetual temptations to violate the law. Because basically, if you weren't held to this standard, then people would just go out here and violate the law just so they can turn around and say, well, I didn't know, and use that as an excuse. So I agree with it. To me, it is right thinking. I agree with it. How about you, Rodney?
I totally agree. I totally agree. Now, and it doesn't matter if you don't agree, because this is what it is.
Exactly. Now, we think this is important. No, go ahead, Rodney. I ain't mean to cut you off.
No, go ahead. I forgot what I was going to say, but go ahead. Yeah, okay. It'll come back.
Yeah, it'll come back. No, I was going to say this is important, and we find this important here at the Power of Offense, because what we have noticed is that most people, most private citizens like us, laymen, right, that's unskilled at law, wait on attorneys and other people, right, who's supposed to be professionals in the field, to tell them everything that they must, or everything they feel that they're supposed to know about the law. But my question to you is, how do you keep your attorney in check? Just like, how do you keep your politicians in check, or your state actors, if you don't know what the law is saying?
Or civics.
Yes. It's important not to be ignorant.
Yeah, and that really is important whenever you're dealing with law, civics, or anything of that nature. And it just brings to light. It reminds me of the 1928 handbook, right? Where it explains this high level of legalese to just private people who join the military. This is like an 18, 19-year-old. They make sure they understand civics and the law in which their government is ran, and is very important. So we have to, where did the disconnect happen? Whereas even people out of high school who go into the military is held to a standard before they can move forward to understand civics and law. But yet now, 90-something years later, we don't understand. Most of us don't understand law. None of us understand civics, and we don't understand why. We understand why, but most don't.
Facts. That's why it's so much confusion out here. A lot of people confused because, again, they're ignorant. They're ignorant of the law. Being ignorant of the law is being ignorant of civics. This is how you know your relation to others, and your relation to government, and their responsibility, duty, and obligations to you. So the whole point that we're driving home, right, is that, again, we are laymen, right? But we're on here giving you our legal commentary, right? The reason we're doing this is because we study the law. The law is not owned by the government. Attorneys don't own the law. Lawyers don't own the law. State actors don't own the law. It's public law, which means that anyone can study it, anyone can learn it, and that's what we choose to do. And this is what we're encouraging all of our listeners to do, right? And you can do it through listening to us, because these are the type of things that we talk about. I don't see anybody on YouTube doing what we do. Attorneys, lawyers, or not. I don't see it.
Right.
You know what I mean? I think what we have here at the Power of Offense is special, because, again, we're showing you that laymen, individuals who are untrained at law, we're not professionals at law, we're not attorneys, we're not lawyers, right? But we still study the same stuff that they study. We can have conversations with them at any time. That's the point.
That's right.
And matter of fact, I'm gonna pull up that manual real quick, Rodney. I'm glad you brought the manual up. I'm gonna pull it up real quick. Now, this is the manual that Rodney just referenced from 1928. Now, this is a citizenship manual, number 2000-25, right? You see it right there in the left-hand corner of your screen. Citizenship manual, all right? And it was issued by the War Department, aka the Department of Defense. The War Department is now the Department of Defense. It was issued on November the 30th, 1928. Now, I'm glad you brought this up, Rodney, because you actually gave me the bright idea to read something, because we're going to go through this book quite often. But I think this one part right here is very important to what we're discussing. Now, right here, I'm reading, and now it says mission, of course. And I'm going to read just one part out of general purpose, number 8. So right here, number 8 in front of you, general purpose. I'm gonna read this, and matter of fact, let me highlight it. This one long sentence that I want to read. It says special emphasis is laid upon the meaning of liberty. All right, so we're going to discuss liberty quite often on this channel, as interpreted by the founders of this republic. So again, we have a republic, not a democracy, and the larger relationship of the individual citizen to others and his government, defining loyalty and national responsibility in terms of citizenship, recognizing that an intelligent and informed people is a greater asset than an unintelligent, uninformed, or misinformed, and that no government can exist upon a plane higher than the moral character of its people. Now, I wanted to read that, Rodney, because to me, what we're discussing as far as ignorance of the law is no excuse goes hand in hand with the last part of this sentence, that an intelligent and informed people is a greater asset than an unintelligent, uninformed, or misinformed, and that no government can exist upon a higher plane than the moral character of its people. Now let that sink in.
Yeah, because pretty much what it's saying is that although you're a layman, which we are, we still are intelligent and informed of the law and civics.
Yep.
So a larger question would be, how did most of the citizens in the United States of America become unintelligent, uninformed, and misinformed, but the government still exists?
Right.
You know what I'm saying? So the government still exists, but most of us are uninformed, misinformed of the law and civic that governs them. So to me, I'm like, wow, it makes sense, because back in 1928, the representatives in the government answered to the people.
Yep.
They went to the people and asked them, the people was intelligent and informed enough to demand, not request, not ask, demand the people they send to represent them in Congress what to do. Now it's flipped, and we go ask the government for stimulus. We go ask the government for this. We go ask the government for that, instead of demanding what we're entitled to. So how did all this come about? We get to that in other videos.
I agree with you 100%, Rodney. How did we get there? We're definitely going to discuss that in upcoming broadcasts. Now, I will throw this out there real quick, Rodney.
And how to correct it.
Yeah. Hey, Rodney, people got to get away from bread and circus. You know what I'm saying?
Yeah. Totally.
Shoot. Exactly. Now, I think we established the point very much that ignorance of the law is no excuse. You know what I mean? It's not. No one has the excuse of ignorance of the law. So again, going back to fair use, right? What this entire broadcast is about, we are addressing the comment, right, that was written by Bachata Intimate to us here at The Power of Offense. Now I'm gonna go back to the comment. We're gonna pull it back up, and then we're going to read another case from the Federal Supreme Court. All right, here we go. Now again, this is what Bachata Intimate wrote. Did you get permission from Kevin Samuels to show his clip? All right, now we're going to answer that question later in the broadcast. All right, we're still going to answer his question. And then he says from lawyer to business owner, right? Meaning that Bachata Intimate must be a lawyer. To the business owners, which is Rodney and I here at the Power of Offense, we own the Power of Offense, right? Fair use is not always as it seems. So this is advice or guidance that Bachata Intimate is giving us. Fair use is not always as it seems. Otherwise, everybody could start a YouTube radio station based on fair use. Now, again, let me stage this. Now, Bachata Intimate wrote this because Bachata Intimate listened to a video that we published that we were analyzing the claims and allegations being made by Jessica, aka Miss Average at Best, against Kevin Samuels, the popular YouTuber and image consultant. All right. So what we were doing, we were analyzing the claims and allegations being made, and we took a look at the video of question, the infamous video where Kevin Samuels was giving advice to Jessica, aka Miss Average at Best. Right? So we did use Kevin's video. We used his video because we had to view the video and discuss the interaction within the video to see if the claims and allegations, right, by Jessica, aka Miss Average at Best, was legitimate. Now she's making a claim, right, that Kevin Samuels violated her privacy. That was the claim. So we wanted to watch the video to see whether we could determine that what she is saying, in fact, really happened. Anything you want to plug in on that, Rodney?
Not really, because once and based on what we saw in the video, we made comments.
Yes. Commentary, comments.
Yeah,
exactly. Here at the Power of Offense, we entertain you with legal commentary from a layman's point of view.
Right, from an informed, intelligent people.
Yes, people that understand that ignorance of the law is no excuse. We're going to I was going to say, not at all. So we're going to go to the law right now. We're going to go to this case law. All right, we're going to see what the federal Supreme Court, the United States Supreme Court, has to say about fair use. That's what we're going to do, because again, we appreciate the concern from Bachata Intimate. Bachata Intimate, we appreciate your concern. Yes, we do. However, right, we get our guidance directly from the source, which will be the federal Supreme Court. All right. Here we go. The case that we're going to look at is Campbell versus Akoff Rose Music, and this is from 1994. Now, we're not going to read the entire case, but what I did find interesting when I was reading through it is that this case dealt with 2 Live Crew. Now, people in our generation, Rodney, I'm at the very tail end of Generation X. Very right. Tail end, like the last year, So I kind of shared Generation X and the millennial generation, you know what I mean? But I remember 2 Live Crew from when I was a youngin',
Yeah.
And they were dealing with, I didn't highlight the song, but this case is dealing with their commercial parody of the song "Oh Pretty Woman." I thought that was interesting. It reminded me of the movie "Oh Pretty Woman Walking Down the Street." That movie is good, but it's unrealistic. Hey, Roddy, that movie got these women thinking they could go out there and be a prostitute and pull a high value man. Really?
That doesn't work. That only works in Hollywood.
You know what I'm saying? But it was a good movie. Don't get me wrong. I did enjoy the movie. Pretty Woman, But yeah, all right, let's get to it. So we're going to scroll past some of it, and we only want to deal with the part that's dealing with fair use.
Go back up to the to the beginning. I mean, right where we started.
Okay.
I thought I saw something. I'm gonna have to put my glasses on. Yeah, right there. It said that this is the question. The question is that we are called upon to decide whether 2 Live Crew commercial parody of "Oh Pretty Woman" may be a fair use within the meaning of Copyright Act of 1976. So that's the question. That's one of the questions that they're attempting to resolve. what's going on with fair use, and I want Keith to break it down by and through this case law.
Yes, fair use. All right, so Rodney just laid it out there with what this case is dealing with, y'all. He just read to you the preamble of the case, which gives us the entire scope of what we're going to discuss. Now, I'm gonna start at number 2 right here, because number 2 goes directly into fair use. It says, it is uncontested here that Two Live Crew's song would be an infringement of a Cuff Rose's rights in Oh Pretty Woman under the Copyright Act of 1976, 17 USC section 106. And then it says, but for a finding of fair use through parody. Now, I want to throw this out there. Normally, we do read through footnotes. Normally, we read the footnotes, and you should always read the footnotes, everyone. But in this case,
number 4, right? Yeah.
But
let them know what that number.
Yeah, that number 4 is a footnote, and we do encourage you to read the footnotes. Now, in this case, we're not going to read the footnotes because I already read them. You know, it's going to take unnecessary time, and we don't need the footnotes to build on what we're saying. So we're going straight through. All right, but we definitely want to throw that out there. Normally, you should read the footnotes.
Yeah,
that's a good practice.
Yeah.
So right here, it says, now we have 575 right here. I highlighted. It says, from the infancy of copyright protection, some opportunity of fair use of copyrighted materials has been thought necessary to fulfill copyright's very purpose, and that is to promote the progress of science and useful arts. Now, this is from the Constitution, the United States Constitution, Article 1, Section 8, Clause 8. I thought that was interesting right there, Rodney.
Yeah.
I didn't know that initially. You know what I mean? I actually learned that from reading this.
Right.
You know,
useful arts and science, all that falls under copyright. So it makes sense, but I didn't understand that either. And then so that makes sense.
Yep. Now it says, for as Justice Story explained. All right. Now a lot of what you're going to see through here is the federal Supreme Court quoting Justice Story. Now, Justice Story is out of Massachusetts, so I figured Justice Story must have been a very bright justice.
Yeah.
You know, but right here it says, for as Justice Story explained, in quotes, in truth, in literature, in science, and in art, there are and can be few, if any, things which in an abstract sense are strictly new and original throughout. Every book in literature, science, and art borrows. It must necessarily borrow and use much which was well known and used before. And that was quoted from Emerson versus Davies, and again, that's out of the Massachusetts circuit, and that's from 1845. So yes, the court does use old case law, just like we use from 1833 when we read to everyone that ignorance of the law is no excuse. That's still good case law. You know, you have some awesome case law from the 1800s, y'all. You really do.
Those are really
the foundation.
Some of the best case law, because it was before, in my opinion, what I call legal corruption now. Within you find case law today, and there's a maxim that protects using old case law that says, and I'm paraphrasing, you remember that it says the older like the older the case the better, something like that. Whatever the oldest is truest.
Right,
remember that maxim, something like that. So when you go back to these old case laws, that's in the true sense of law, because and the one right below, the 1803, that's less than 40 years from when the founding thieves did the Declaration of Independence and Constitution. So that's in the truest sense of the Constitution and the Declaration of Independence, these old case laws. And then after that, it is what it is. Go ahead.
That is facts. That is facts right there, y'all. Please take note to what Rodney just dropped on you. That was a golden nugget. Now, the court goes on and says, similarly, Lord Ellenborough expressed the inherent. Sorry about that. Let me just start over. It says, similarly, Lord Ellenborough expressed the inherent tension and the needs simultaneously to protect copyrighted material and to allow others to build upon it when he wrote, in quotes, "While I shall think myself bound to secure every man in the enjoyment of his copyright, one must not put manticles upon science." Now, manticles would mean, it basically means restraints, right? So no one should put restraints upon science. Now, this was cited from a case out of, or should I say from a court out of England. Now, for those who don't know, that American jurisprudence actually follows the English common law. Now, there are some differences, but a lot of American jurisprudence is based in the English common law.
And just another side note, English common law, if you're from the state of Maryland and you read Maryland Constitution, which encompasses the Declaration of Rights, because the United States is the Bill of Rights. So Maryland's Declaration of Rights. Maryland Declaration of Rights actually says that we can use English common law in the state of Maryland.
Yep.
So that supports what Keith said, and it's constitutional.
Yep.
If you're in the state of Maryland.
Yes, it is.
And if you know how to use the Constitution, you can use it in any state.
Facts.
But that's another story.
Facts. And you know what, Rodney? I think one day we should cover the Maryland Constitution just so people can see that.
Yeah.
You know what I'm saying? But yeah, the English common law is protected in Maryland. You could actually use the English common law.
The Magna Carta, all that, you can bring it up. Right to travel. It's a whole lot in there.
You're right. You're right. Now, the court goes on and says, and I highlighted right here at the top, it says, in copyright cases brought under the Statute of Anne of 1710. So copyrights existed way back then, y'all. It says English courts held that in some instances, fair abridgments will be what we call fair use, right? Would not infringe an author's rights. And then it goes on right here, and it says, and although the first Congress enacted our initial copyright statute act of May 31st, 1790, 1 Stat 124, without any explicit reference to fair use, as it later came to be known, the doctrine was recognized by the American courts nonetheless. All right. So the court goes on and says this, and let me scroll down some. All right. Right here, it says in Folsom versus Marsh, and again, this case is from 1841, Justice Story distilled the essence of law and methodology from earlier cases. In quotes, he said, look to the nature and objects of the selections made, the quantity and the value of the materials used, and the degree in which the use may prejudice the sales or diminish the profits or supersede the objects of the original work. Thus expressed, fair use remained exclusively judge-made doctrine until the passage of the 1976 Copyright Act, in which Justice Story's summary is discernible. All right. So the passage of the 1976 Copyrights Act, right, was predicated upon the brilliant work of Justice Story in Massachusetts. Now, I think that's pretty awesome, man. That's beautiful to go on the resume.
That's right.
All right, so here we go. Section 107. Now, this is what Bachata Intimate was talking about, fair use. All right, this is now we get into it, y'all. It says fair use, notwithstanding the provisions of section 106 and 106A, right? Now that deals with specifically copyrights. Now this section 107 deals with fair use. It says the fair use of a copyrighted work. In this case, it will be Kevin Samuel's video that we use, which was his advice to Jessica, aka Miss Average at Best. That's the video that we was analyzing to see whether she has a valid claim of privacy violation or violation of her privacy. All right. Right. Now it says including such use by reproductions in copies or phono records or by any other means specified by the section. So that would include that does include a digital video such as Kevin's. It says for purposes such as criticism, comment. Now again, remember when I read that first definition in Google, they didn't say anything about comment. All right. They didn't say that. You noticed that too, right, Rodney?
I did.
And I told everyone, I said, comment is a part of it. And if you look at our slogan, right, our notice that we put in all of our videos, we tell everyone, right, that here at the Power of Offense, we entertain you with legal commentary, you know, commentary, right, from a layman's point of view. So that's how we entertain everyone, right? Now,
Right.
it says news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright, right? So the fact that we're giving commentary. All right, let me read it from the top. It says, notwithstanding, right? Now we're reading the limitations on exclusive rights, fair use. That's what's highlighted. And it says, notwithstanding the provisions of section 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phonorecords or by any other means specified by that section for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include. So there are 4 factors that's right there, 4 factors, right, that shall be considered, and all of them must be considered in order for fair use to exist, right? So we already established that what we do here at the Power of Offense is commentary, as in commentary. So when we reviewed that video, Kevin Samuel's video, when he's giving Jessica advice, right? The same video that he's being sued over, we were giving commentary, as in comment on that video. All right. So we establishing that. So just right there, you know what I'm saying, Rodney?
Yep.
We were commenting on it. So now we need to look at the 4 factors. Now, the first factor, it says number 1, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And number 4, the effect of the use upon the potential market for or value of the copyrighted work.
Now, I just want to, you don't have to pull it up. I'm just going to say it. And if anyone want to pull it up to read it themselves, they can. The definition of commentary is an expression of opinions or offering of explanations about an event or situation, which is exactly what we did with the Kevin Samuels video. The fact that the word comment was not in Wikipedia, Keith just talked to you about primary sources. So even though it wasn't in Wikipedia, which may be what Mr. What's his name?
Bachata Intimate
may have read and read only. So that secondary source that he read is subject to the primary source, which what Keith is reading, which is the Supreme Court case of the United States of America. I just wanted to lay that out. So we're using that primary source, the Supreme Court, to support our position versus a potential secondary source, Wikipedia or another piece of a source that was used by Mr. Bachata.
Yes, indeed. I appreciate you dropping again another golden nugget on him, Rodney. Commentary. Commentary.
Yeah.
But yeah, the also this is the last part of section 107 right here. I'm gonna highlight it real quick. It says the fact that a work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all the above factors. So again, all of the above factors are used to determine whether the fair use doctrine applies to any particular work. Now, we can assure you here at the Power of Offense, Bachata Intimate, and all others, that our work that we did on the Kevin Samuels lawsuit, right, that we're protected under the fair use doctrine. And we're going to prove that right now. All right. Now it says,
you're gonna further prove it because you just proved it. But you go ahead and further prove it because we like extra.
Yes, we're going to further prove. Thank you, Rodney. Thank you for the correction. It says Congress meant Section 107 to reinstate the present judicial doctrine of fair use, not to change, narrow, or enlarge it in any way, and intended that courts continue the common law tradition of fair use adjudication. It says the fair use doctrine thus permits and requires courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which the law is designed to foster. And that was cited from Stewart versus Abin, 1990. So the Supreme Court, the Supreme Court like to cite themselves, y'all. They cite previous cases. Now it says the task is not to be simplified with bright line rules for the statute, like the doctrine it recognizes calls for case-by-case analysis. So whenever the courts are dealing with a fair use issue, right, it's by case, it's a case-by-case analysis. So it's all done case by case. This is what they're saying right there. Now the court goes on and says right here, and I'm gonna highlight this, it says the text employs, right, and they're talking about the text in it says the text employs the terms including and such as in the preamble paragraph to indicate the illustrative and not limited function of the examples given in section 101, which thus provide only general guidance about the sorts of copying that the courts and Congress most commonly had found to be fair uses, nor may the four statutory factors be treated in isolation one from another. All are to be explored and the results weighed together in light of the purposes of copyright.
So in other words, they're challenging the intent.
Yes.
Saying the intent behind what you're claiming to be fair use. You know what I'm saying? So That's what it's saying, and that's what it's protecting, and that's why it's case by case. You don't need all those elements, just like we discussed in one of our previous videos. Whenever you're dealing with a cause of action, you have to meet all the elements. Mm-hmm. This is telling you can just meet one of the four, but they're gonna take it case by case, and they're gonna really dive into the intent of the fair use claim versus the fair use defense.
Right. Yep. Yes, indeed. Now, A, right here, it says the first factor in a fair use inquiry. Now, for those who don't know, you have inquiry, which most of us are familiar with. This begins with an I, right? But you also have inquiry with an E. Look it up. Now it says that. Now I'm gonna start over. It says the first factor in a fair use inquiry is the purpose and character of the use, including whether such use is of a commercial nature or is of a nonprofit educational purposes. And then it says section 107.1. It says this factor draws on Justice Story's formulation that the nature and objects of the selections made. And then it says the inquiry here may be guided by the examples given in the preamble to section 107, looking to whether the use is for criticism or comment. Again, ours is comment, commentary, comment, or news reporting and the likes. And it says see section 107. Now, the central purpose of this investigation is to see, in Justice Story's words, whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. Now, it goes on and it says, although such transformative use is not absolutely necessary for finding a fair use, the goal of copyright is to promote science and arts, and is generally furthered by the creation of transformative works. Now, let's make this clear, that the work that we did, right, was transformative. And the reason why it was transformative is because we took the video, right, the infamous video where Kevin Samuels was giving Jessica, aka Miss Average at Best, advice. the same video that he's being sued upon. We took that video, right? And we gave our analysis, right? Which in turn is legal commentary from a layman's point of view, meaning our unskilled at law point of view, right? We gave our analysis of whether we believe Jessica has a valid claim, right? A valid cause of action, whether it exists, right? Being a violation of her privacy. So right there, that's transformative. We created a new work based upon Kevin's work. That's what we did.
Right.
That's what we did. That's protected under fair use. That's the first factor. So is the work transformative? Yes, it is. We can agree to this, can't we, Rodney?
Absolutely.
And I'm pretty sure, but Child of Intimate, I'm sure you have to agree to it also. That our work was transformative. You know, we weren't on there giving advice. No, we weren't. That's what Kevin did.
Opinion.
We were giving our opinion based upon the interaction between Jessica and Kevin Samuels. Whether we saw, in our opinion, that she had a valid claim for her privacy being violated. That's simply put what it was. Now let's move on. Now right here, it says, such works, right, does lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. And it says, and the more transformative the new work, the less will be the significance of other factors like commercialism that may weigh against a finding of fair use. So again, our work is completely transformative, completely. Yeah. And this is, and what the court just said right there, this is the most significant factor that they look at. Was this transformative? Yes, it was. We didn't supersede what Kevin did. We weren't giving advice. You know what I'm saying, right? We weren't giving dating relationship advice. No, we weren't. We were given our commentary based upon our analysis of Kevin's interaction with Jessica to see whether she had a valid claim, right, for a violation of her privacy. Now we're going to skip this next paragraph, all right? Because the next paragraph is talking about parody. We're not dealing with that. We're dealing with comment, as in commentary, right? But we just want to make sure we take all of the important elements from this concerning the fair use doctrine. So we don't have to go into the 2 Live Crew situation for us to do that, not completely. You know what I'm saying?
No, we don't. I think we pretty much made our point.
Well, I want to go through the other 3 factors too. Yeah, I want to go through the other because I don't want Child of Intimate or anyone to try to say, well, yeah, they were right, but you know, thus far, but they didn't finish. You know what I'm saying, Rodney?
Right.
So right here it says the second statutory factor, the nature of the copyrighted work, and this is section 107.2, draws on Justice Story's expression, the value of the materials used. This factor calls for recognition that some works are closer to the core of intended copyright protection than others, with the consequence that fair use is more difficult to establish when the former works are copied. And then it goes on, it says contrasting fictional short stories with factual works, contrasting soon to be published memoir with published speech. And then it says contrasting motion pictures with new broadcasts and contrasting creative works with bare factual compilations. Now right here, I'm gonna highlight this. It says we agree with both the district court and the Court of Appeals that Orbison's original creative expression for public dissemination falls within the core of the copyright's protective purposes. It then says this fact, however, is not much help in this case or even likely to help much in separating fair use sheep from the infringing goats in a parody case, since parodies almost invariably copy publicly known expressive works. All right, so again, you know, the value of the materials used, right? So the values of the materials used would be, if I'm not mistaken, let me see something real quick. All right. Basically what I'm trying to say is this. Again, we passed factor number 2 because, our work, right, is quite different. And it's not even close to the original work. The original work, again, is Kevin Samuel's advice to Jessica, aka Miss Average at Best. And that was an advice that he gave her. So that video was predicated upon his advice on dating and her image, right? The work that we did based upon his work was an analysis of the video to see whether, right, she had a legitimate claim for a violation of her privacy. So the way that our work, in contrast to his work, right? Our work is an analysis and is commentary on the facts in that video, right? To make a determination. And his work is advice. So it's totally contrast, totally different. So we definitely pass factor number 2. Now, factor number 3, it says the third factor asks whether the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And this is from section 107.3. And then it says, or in Justice Story's words, the quantity and value of the materials used are reasonable in relation to the purpose of the copying. Here, attention turns to the persuasiveness of the parodies justification for the particular copying done, and the inquiry will harken back to the first of the statutory factors. For, as in prior cases, we recognize that the extent of permissible copying varies with the purpose and character of the use. Now, I'm gonna stop right there because let's make it clear, since we're dealing with quantity, right? We use. Now, I'm not sure if you noticed Bachata Intimate, because you may not have seen the full video, but the full video that we published in reference to this particular, that particular video of advice between Kevin Samuels and Jessica, aka Miss Average at Best, right, was 1 hour and 45 minutes. Now, we took a 20-minute video clip from Kevin Samuels where he's giving Jessica advice, and we put in that video, his 20-minute video is within our video of 1 hour and 45 minutes. So we have a whole hour and 20 minutes of analyzing what we saw
within that 20 minutes.
Yes. So again, we would definitely pass this portion. Technically, we didn't even use much of his work, but we had to use his work in order for our audience to
get a full understanding.
Yes, of our analysis. Yes. So let's keep going, and we're going to read this fourth factor. Now, here we go. Fourth factor. It says the fourth factor use. Sorry about that. It says the fourth fair use factor is the effect of the use upon the potential market for the value of the copyrighted work. And this is from section 107.4. It requires courts to consider not only the extent of market harm caused by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by the defendant will result in a substantially adverse impact on the potential market for the original. All right. And it says the inquiry must take account not only of the harm to the original, but also to the harm to the market for derivative works. Now, I'm going to stop right there and just make it clear that I don't see any way that our video, right, will harm Kevin Samuels. I don't see any way that it would.
This part right here doesn't even apply, because this fourth one is really talking about bootleggers. You ever bought a bootleg video or bootleg tape? You buy the whole content, but it affects the market of the person's original copy work. So right. That doesn't apply. Just like if you used to buy up in New York about those bootleg tapes, those bootleg movies, those bootleg when they make copies of people DVDs and tapes and sell them on the street. That's what number 4 is talking about.
Well, yeah, and that would be a superseded work.
Yeah,
you know,
and
that's not transformative.
When they start talking about market value, is how much money you're stealing from the person who originated the work.
Right, which we're not stealing anything from them.
Exactly.
But I did want to point this out, though, Rodney. I did want to point this out to you, is that I think it's right here, the first factor. Right here. Because I just want to make sure people understand clearly that all 4 of the elements or the factors are weighed against any type of fair use claim. Do you get what I'm saying?
Yeah.
Excuse me. It says Congress. Well, I want to read this real quick. It says Congress most commonly had found to be fair uses. You know what? No. Let me start right here. I should start probably right here. It says, nor may the 4 statutory factors be treated in isolation, one from another. All are to be explored and results weighed together in light of the purpose of copyright. That's why I wanted to make sure we covered all 4, because the court is supposed to explore all 4 of them if they're dealing with a copyright, fair use issue.
So that corrected me then, because I was saying that it wasn't like the elements of a cause of action, but this right here is the elements of the cause of action, but it's not as strenuous.
Right.
With a cause of action, if you miss one, you done. But this right here, they're gonna weigh all of them, and then they're gonna see how each one weighed within each particular matter.
Yeah. I wanted to make sure, because I thought that's what you said earlier, but I just wanted to make sure that we cleared that up.
Yeah, that was a good look right there.
Yeah. So right here, now we just went over this case. Now again, we're not reading the whole case, y'all. We read just enough to cover fair use or the fair use doctrine. So now we know that the work that we published, right, was a commentary, meaning comment, right? We were giving commentary on a video that Kevin Samuels put out, where he was giving advice to Jessica, aka Miss Average at Best. And that particular video, Kevin is in litigation over. Jessica is suing him, saying that her privacy was violated. So what we wanted to do is see whether we can actually determine if she had a legitimate cause of action under a privacy tort. That was the purpose of us doing that particular video. So we're going to take everything that we just went over, right? And I actually pulled this from copyright.gov, which kind of simplified it. You know what I'm saying, Rodney? Now you could go to copyright.gov, y'all, and you can find information specifically on fair use.
But this is a secondary source.
Right. Well, copyright.
This is a secondary source.
I say this. I think this is the best, because we got to explain why you're saying it, Rodney.
Yeah.
Copyright.gov is a primary source. It is, because it's a government source, but it's a secondary source to the federal Supreme Court, which had the duty to interpret the copyright law, including the fair use doctrine, for the executive branch, of which the copyright.gov exists on, so that they know the proper way to operate. Did I explain it right? Oh, good, Rodney?
Yeah.
That's basically why you're saying that.
Yeah, exactly. Yeah.
Right. Now, when it comes to, like, when we first looked at the definition, I think this is right here. When we first looked up this definition of fair use, and this came from, I believe this came from google.com, but I believe they're pulling it from Oxford right here. Definitions from Oxford language. I believe this is where they're pulling it from. This is a secondary source. So in comparison to this definition on your screen, everyone, copyright.gov will be a primary source. But But in comparison from copyright.gov to the federal Supreme Court, this case from the federal Supreme Court would take precedence over what copyright.gov is saying. That's what Rodney is basically saying.
And I have no doubt that the copyright.gov got its information from those old case laws back in the 1800s.
Right, exactly.
The Copyright Act was created in 1976. They just explained it in the case that you just read, where the Copyright Act came from. Hence, the copyright.gov is part of that. So it is giving you like a chain of title.
Yep, exactly. And this is the United States Copyright Office. Now, to me, this will be the best thing for everyone to read, especially starting off. Judge language, or the King's language, which is the language of law, can be challenging for newbies. It can. Yeah. You know what I mean? To me, I think copyright.gov actually explains it in a much simpler way, and they're generally saying the same thing. But the importance of what Rodney just pointed out concerning the federal Supreme Court case law taking precedence even over copyright, or the United States Copyright Office, is that sometimes, because we have seen this before, sometimes the Copyright Office may have something wrong on their website, right, or be missing something that's in the case. This is why it's a good practice to go back to the case and read case law.
Exactly.
So that's basically what you're trying to relay. Am I right, Rodney?
The same thing with the definition. The definition didn't have comment.
Yeah, it didn't have comment. Exactly.
You know, so we had to go to the source so we can get all that entails with the definition of fair use, and then express it by and through the case law.
Exactly. So yeah, I think this is an easy way. Again, it says the same thing. It talks about the commercial nature, nonprofit. It basically everything we just covered. There's no point in us reading this, but I just wanted to show this to everyone. If they have any questions, and let's say they're intimidated by reading the case law, you can go on copyright.gov and read this short write-up on fair use. So I definitely wanted to say that. Now, at this point, Rodney, I wanted us to go back to the question. Go back to the question that was given by Bachata Intimate. Now, the question is, did you get permission from Kevin Samuels to show his clip? The answer is no. And the reason why we didn't is because we didn't have to. We didn't have to is because we use fair use. Under fair use, you don't have to give permission. Now, from lawyer to business owner, right? Again, we appreciate the unsolicited advice from you being a lawyer to us business owners, right? Fair use is not always what it seems. That's true, unless you understand what fair use is, like we do, right? So we understand what fair use is, and we know that we were within the scope of the fair use doctrine, right? So we would like to put this challenge out to you, because again, we appreciate your comment. We appreciate your concern, because we believe that you want to keep honest people, honest, right? So we appreciate that.
Yeah. So this would be from business owners to lawyer. But go ahead with the challenge.
Yeah, from business, I like that. From business owners to lawyer, we would like to challenge you, right? To challenge what we just presented, if you can, and to come on to our channel, right? We could do a live broadcast where you could present the facts to support your claim that we violated the fair use doctrine,
or potentially violated the fair use. Because we can everything that we just presented is excellent, but to cap everything off, if Mr. Bachata was representing Kevin Samuels, he would be representing the wrong party. One, because Kevin Samuels' videos are not copyrighted. So all that shit went right out the window right there. It would have to be YouTube, because I'm sure that they had their contents copied. They would have to come and say, hey, this material is copyrighted, if they can prove that, and they still would lose. Right. So the mere fact that Kevin Samuels' videos, none of them, and I haven't seen any YouTube video copywritten. I don't even know if you can copyright a video. You can trade probably a movie, but probably a video too, but it wasn't copywritten. So the fact that it wasn't copywritten, all this is moot. M-O-O-T, that's a legal term, means it doesn't mean anything.
Right. But on the assumption, let's say it was copywritten, but we still fall within the fair use doctrine.
Still fall within it.
Yep.
Yeah, that definitely. And when you deal with like attorneys and what we were saying earlier about attorneys and the people of the United States being unintelligent, uninformed, and misinformed, and misguided, all the above. And we rely on lawyers, attorneys, and judges to assist us in law. You know what I'm saying? They trained us. They trained us to go to them to learn the law. But Keith just told you, ignorance of the law is no excuse. But they trained us to believe that lawyers, attorneys, and judges know the law that will help us, and that's not true. You know what I'm saying? So you know, we used to listen to, or I still do. I think you still do too. A radio station that came on daily. We don't have to mention the name, but that radio station have a lot of good, strong-minded, educated, knowledgeable people that come on this show. Am I right or wrong? You know the show I'm talking about.
Yeah, you're right. You're right.
Yeah, a lot of nice people. I mean, I learned a lot from a lot of the guests that come on this show, and a lot of guests, many guests that come on the show are attorneys. So when Keith first introduced me to this radio station where you can call in, interact with the guests, I mean, it's a great show. It's a great show, and I would listen to attorneys come on the show when I first heard the show, and I would get somewhat offended by what they were saying. You know what I'm saying? What they were saying, I was like, damn, what are they talking about? I used to think they were wrong.
Right.
I say, these attorneys are lunching, Keith. They saying this, and this. What's going on? I'm thinking that they're intentionally misleading the public. And then he has another guest that come on, older gentleman, super sharp, broke something down to the audience, and I was part of the audience listening. And I asked the question, like what the person said. He said, questions and answers will solve pretty much all problems. Ask questions. Don't make statements, ask questions. So when I used to call into the show and challenge the attorneys, the guests used to get mad at me because I was challenging maybe in an assaulting way what the attorney or lawyer or judge was saying, because I knew what they were saying could potentially be harmful to the people, right?
Right.
So I asked myself a question. This was after like a year listening to it. I done got barred off the show. They only let me call in. I used to call him and just straight and straight, but not realizing I was disrespecting his show. But it wasn't. Right. It wasn't my intent. I'm trying to help educate the people. And I used to said, you can't even stop answering my call like you had it or like had me on block. You know how you block somebody's number?
Yeah.
So what I did, I took the older guy advice. I asked myself a question. I said, who teach lawyers, judges, and attorneys law in the United States of America? That was a tricky question. I asked that question to myself. I said, who teach them law?
Right.
So I would ask people, I said, who teach y'all law? And they would say, the law school, professors, this and that. So I said, well, that's not the answer I need. So when I asked myself the question, I said, who teach lawyers, attorneys, and judges law in the United States of America? My answer was to myself, the system of racism and white supremacy. The system of racism and white supremacy, which is all of our educational schools from K to 12, higher learning schools, which are colleges, law schools, and so forth. That's under their system, the educational system. That's the system of racism and white supremacy, whether you understand that or not. So when I asked myself that question, I said, who teaches them law? I said, that system does. Then I asked another question, which may have been even more important to myself. I said, well, Rodney, do you think the system of racism and white supremacy would teach lawyers, attorneys, and judges to free and emancipate our people? I was talking about Black people at the time. Mm-hmm. The answer to that question was hell no. So then I broadened the question and said, well, do I think the system of racism and white supremacy and those who support it, because those who support it, like you and I, Keith, they're Chinese, they're Mexicans, they're Arab, but they still fall under the guise of the system of racism and white supremacy. Why? Because they won the war. Mm-hmm. So they won the war. They may not own the planet, but they got one better. They control it. Right. If you don't believe me, fly an airplane up in the air and don't respond when they say, who I am, who are you? Take a boat out in the water and don't respond when they say, who are you? And you will quickly find out who controlled the air and the sea.
Yeah, I agree.
Walk on land, walk up in Congress, or on the Capitol grounds or walk anywhere and let one of those officers, one of those federal agent, state agent, any of those agencies that fall under that executive branch, let them ask you some questions and you don't respond the way you ought to respond, and you will quickly see that control unleashed, right? So with that being said, I said, well, who teach the law to attorneys, lawyers, and judges? Will that law help any people in the United States? The answer to that question, to me, appears to be no, because there are so many uneducated, unintelligent, and misinformed people based on the system that we went to school. The only reason me and Keith and I can present commentary like this in a legal fashion, because we studied it ourselves. Now, what they teach in law school, they have a curriculum. In law, what they teach law school, all the law that they learn is accurate. So I was wrong when I was called a radio show and say, y'all are crazy, y'all misleading the people, because all the laws that they were saying are on the books. But the law that Keith and I learned, study, the thousands of hours in the Library of Congress, the National Archives, reading case law, what Keith just did, and in addition to that, going into court and applying it. So that was our private learning right there. And we get our law from the same hub that the lawyers do. So the law that we learn and the law that we use are on the books, but not taught in law school. So if it's not taught in law school, it's not presented to the people when you go pay your money for a lawyer and attorney, which is why most people get misled and get locked up, and which is why Kevin Samuels will probably lose this case if he keeps saying expectations of privacy and everything else that he was saying on his show with the other brother. I forget the other brother name.
Donovan Sharp.
Yeah. So if those defenses, it appears that his attorney was telling him, he's going to be in trouble when this lawsuit kick in, if and only if Ms. Jessica attorneys present the case properly within the scope of illegal use of her image without without sharing the profits thereof.
Right.
You see what I'm saying? So we're not trying to disrespect Mr. Bashada or any lawyer, attorney, or judges, because I have a few of them on my cell phone. I call them if I need any type of procedure that I don't feel like researching myself. If I don't feel like researching a certain procedure myself, procedure law is much different than common law. It's a lot. This law is broken down a lot of different categories. It's all start from natural law
and Rodney,
law, and it breaks down.
And
so
we tend to use
law.
No, I mean, cut you off. I was gonna say, and we tend to use constitutional law because we understand that the Constitution is the rules of the game. That's something they can't get past. It's the supreme law of the land. I wanted to throw that out there. That's why it seems as if the law that we use is a lot different than a lot of what they use, because we like to use the Constitution on them. Yeah,
we like to use the Constitution. One, why? Because within Article 6 of the Constitution, all judges and people who take public oath are bound by it. Bound mean you have to follow it. Whether they follow it all the time, we know they don't, but they're supposed to. So it's no disrespect to Mr. Intimate or Mrs.
Bashada Intimate,
the male or female. Bashada, we're not sure the gender, so we're gonna say the person.
Right.
So, but what we just laid out, Keith and I know is undefeatable. However, if you believe you can defeat it, or if you want to add commentary to, we more than welcome you to the show to give your legal perspective, your legal commentary based on what we just laid out. And that's pretty much all I had to say.
Yes, we definitely invite you. Please come on to the show. We're going to drop our email down in the description box for you to send us an email, and you're more than welcome. We would enjoy it. And again, it's not like it's going to be a hostile show. It's not going to be anything like that. You know, we operate in peace the same way that we show that you are, because our belief is that your message was out of concern that, again, honest people are being honest, that we're following the law of fair use. That's what we get from the comment that you left us, Bashada Intimate. And I did want to say this, Rodney, too, before we finish out. I want to make sure I say this.
is that, again, ignorance of the law is no excuse. We're not excused by the law, and but child intimate or any attorney, they're not excused neither. No one is excused for being ignorant of the law. But the point of me bringing it back up is that I feel that it's important as private citizens, as laymen, for all of us to learn American jurisprudence in some form or some aspect. And the reason why I'm saying this is because even if you do need an attorney, right, to help you with your affairs, how do you make sure your attorney is honest? How do you make sure your attorney has integrity and your attorney is following the law? Because if you don't know these things or even basic principles of law, you don't know whether your attorney is screwing you over or not. All you know is what your attorney says. It kind of reminds me of, and again, this is, I mean, it's fiction, it's television, it's Power. Do you watch Power, Rodney? Just curious.
I do not, but my wife does, so sometimes I listen to it. Okay.
Power Book 2, right? Mm-hmm. It just went off, I want to say a few weeks ago, and Method Man was actually a highly regarded and highly paid attorney on that particular show. And he was actually working against his client, which was Tasha St. Patrick. Now he's working against his client with the prosecution, which is the Federal Attorney General Office in New York. He's working with them, right, against his client. Now it's easier to determine these things and know what's going on when you actually understand the law.
Yeah,
it's easy to determine if you're man. You can read through it if your attorney's being honest and has integrity, or and they trying to brush you off.
Yeah, exactly. And a lot of times, the law that they're using is good law. Just like I was saying, the law is on the books,
right?
But it's not the best law for your situation.
Exactly.
You see what I'm saying? So we have to use the best law, to help your situation, not the law that they're presenting. And you and I both know real life situations where attorneys work against real people.
Exactly.
Witnesses.
Yeah.
You know what I'm saying?
Oh man. And it's case law to protect them. It's case. You know what I'm saying, right? It's case law to protect your attorney if for whatever rights that attorney may have not. I'm trying to couch what I'm saying, right? But whatever rights the attorney may not have raised during the trial, they're actually protected,
right,
against you basically suing, against liability. Yeah. This is why we have a duty to know, man. I'm telling you, it's dangerous. It's harmful. Back to that maxim. It's harmful.
It's harmful. And in addition to that, it's over like 6 million laws, statutes, codes, and it's over 6 million in the United States. Over 6 million.
Yeah, that's a lot.
Around about. And believe it or not, we got a duty to know all of them.
Right.
You know what I'm saying? And when I figured that out, I was like, man, that's a lot of law to learn. I was probably spending the rest of my life trying to read that, which took us to the supreme law of the land, the Constitution. I said, let me deal with the Constitution and match all those 6,000 laws up against the Constitution and see what stick. I'm not reading all those laws. It's too many. It's too many laws to read. So it's best to read the highest law and work your way down.
I agree.
So any law come against you, match it against the Constitution, match it against your state constitution, and see how it fares. Because trust and believe, your legislators in Congress and your state legislators pass a many law that is repugnant to the Constitution. And according to the Supreme Court of the United States, any law repugnant to the Constitution is void.
Yeah, I forgot what case that is. Yeah.
It's a few, and that's an 1800 something. That's the 1800 case as well.
Yeah, I want to say is Merlin. I want to say is it Merlin versus or somebody versus Merlin? Oh God, they'll come back to.
So many, but I don't remember the case law in particular, but I remember what it says.
Yeah. It's there. It's on the books, and it's good case law. Right. Matter of fact, we're gonna have to find that. I think that'll be a great show for us to go over that.
Yeah.
You know what I'm saying?
So instead of being shocked that you have to know all these laws, we are faced a lot of laws, what they call law, statutes and codes that just infringe so much against our rights protected under the Constitution. And the mere fact that we don't know, the mere fact that we're misinformed, the mere fact that we're unintelligent, the mere fact that we're uninformed, whatever I'm trying to remember what
Uninformed, misinformed, and
yeah.
unintelligent.
Yeah.
Yeah.
The fact that we're all those leads me to believe that these attorneys can easily take advantage of us because we don't know. Why don't we know? Because we wasn't taught in school. In 1928, people was taught this in school. That's why they
Yep.
couldn't get over. So it took them 90-some years to get us to the state that we're in as being an unintelligent people. But we have to turn the tables, as it say in the Bible. It's time to turn the tables.
Yep.
Put the shoe on the other foot and adjust those scales. Why do you think all the scales supposed to be balanced of my eye?
Mhm.
You know what I'm saying? But every scale you see in the justice system of the United States is tilted.
Right.
It's tilted for who? It doesn't appear to be tilted for us.
I was gonna say the elite. I was gonna say the elite because
exactly. So it's time to turn the
Yeah.
table, and we can do it. It's an easy fix, but you're gonna have to read. You're gonna have to understand. You're gonna have to be confident, and that's the way that we put our public officials, our public actors, our state actors in check. Attorney is a state actor because they take an oath to the Constitution.
yes, sir.
You know what I'm saying? So any attorney, you can tell them what to do. Don't ask the attorney. You tell attorney what to do. If you don't want to do, fire him.
Yep.
Think any public official that took an oath to the Constitution, they have to follow it. But if you don't raise it, what you do, Keith?
You wave it. You wave it.
We can close with that one. What else you got to say?
Yeah, no, I was gonna say, yeah, I think we should close on that one, man.
Absolutely.
I think this was another hot show. Again, here at the Power of Offense, we entertain you with legal commentary from a layman's point of view. And please share, like, and subscribe.
Peace.
Peace.